Now, before we cover any of those stories, there is also so much else happening in the news. So here's a special report about what else is trending in the country today.
Here are today's top crime stories trending on Law&Crime.com and across the country. Nebraska's first execution in over 2 decades was carried out using a drug combination never tried before that included the powerful opioid fentanyl. The death row inmate, 60-year-old Carrie Dean Moore, is the first inmate executed in Nebraska since 1997. He was convicted for killing 2 cab drivers in Omaha in 1979 and sentenced to death. Moore's execution went off without any complications. A suspect on the FBI's 10 Most Wanted list was caught on camera dancing as he was extradited from Michigan to Georgia to face murder charges. Antoine Mims is accused in the fatal shooting of 2 men at a party in Brenton Harbor and was arrested in Georgia in July. Mims faces charges of first-degree murder, possession of a firearm by a felon, and other felony weapon charges. A father in Arizona is facing charges after he reportedly killed a man who tried to enter a bathroom stall occupied by his daughter. 40-year-old Melvin Harris III was arrested and charged with the beating death of Leon Levon Armstrong at a Quick Trip convenience store in Phoenix. Armstrong allegedly tried to forcibly enter a bathroom stall Harris's 16-year-old daughter was using. Harris confronted Armstrong once his daughter identified him as the offender and beat Armstrong to death. Harris is now facing a charge of second-degree murder. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Great reporting as always, Anthony. Go to lawandcrime.com to learn a little bit more of the top trending stories of the day. But we got to talk about this bathroom stall killing. And to help me talk a little bit more about it, joining me, I haven't had him on in a while, former federal prosecutor Kendall Coffey. Kendall, great to have you back here on Law and Crime.
Thanks for having me, Jesse.
Now, how many fathers, when they hear this story, fathers of daughters, may have done the same thing here?
Well, a lot of fathers are thinking, in that situation, I would have been filled with rage. In that situation, I would have wanted to go after the guy. But, you know, I think most fathers understand the law, that you're not a self-appointed punisher, much less a self-appointed executioner. And unless he can establish that there is self-defense, which is going to be very tough here, because the harm, it appears that the danger to his daughter had passed by the time she came back to the car and by the time that he confronted Armstrong. So there's a lot of sympathy for this kind of situation, but at the same time, recognition people can't take the law into their own hands. And when someone is beaten to death, whatever might be a jury's initial sympathy, especially if the defense is successful in getting a number of fathers of daughters on the jury, that the brutality of a beating to death is going to be something that is very upsetting to the jury. So there is not a jury pardon in this scenario, perhaps a conviction on a lesser crime.
So can you say any way that the threat was still there? That, look, if I didn't intervene, if I didn't do something, who knows what could have happened? Is there any way he could frame an argument like that?
Well, he absolutely has to. He has to suggest that Armstrong was menacing. Armstrong made movements that suggested he might have had a weapon. I mean, there are almost always going to be opportunities for the defense lawyer to suggest different scenarios by which Armstrong was still dangerous. But you've got witnesses here. And what the witnesses will apparently describe is a brutal beating rather than a defendant who was being threatened by either imminent physical harm that was serious or imminent death. Because those are really the standards for self-defense. A reasonable belief of imminent serious bodily injury or a reasonable belief that death was confronted.
And we know that he already approached a security guard first to handle the situation, and then he took matters into his own hands. I wonder how that might hurt his case or help his case, but it'll be interesting to follow. And one last thing, if he's convicted, what could he face? How many years in prison?
Well, the conviction is going to depend heavily on whether it's second-degree murder or some form of manslaughter. Manslaughter is still going to put you in prison, but it's typically less than 5 years. Second-degree murder, could certainly be double digits in terms of the years he faces.
Pretty unbelievable case. We're going to have to follow it a little bit more here on Law and Crime. And if we have an update, we'll make sure to let you know. Kendall, thank you so much. Stand by. I'm going to have you on because we're going to talk about the next chapter of our saga here on Law and Crime. And that is the Shayna Hubers case, the young woman who's charged with the killing of her boyfriend, Ryan Poston. As I said, our very own Aaron Keller has been in the courtroom, and we have a special report about what has been happening in the trial so far. Take a look.
The second day of testimony in the Shayna Hubers case here in northern Kentucky involves some racy text messages back and forth between the defendant and a former friend. They met because the friend was going to dental school, and Shayna Hubers expressed an interest in dentistry. Now, that friend testified that they used to gripe back and forth about failed relationships on each side of that friend equation, but that Shayna Hubers said some very bizarre things. One thing Shayna Hubers said was that she wanted to take victim Ryan Poston to the shooting range, turn around, kill him, and make like it was an accident. Now, on cross-examination, that witness said she didn't take anything of that comment when it was made, that this was just griping, and they usually said some inappropriate things as a way to blow off steam. That was testimony from a friend. A police officer who was with Shayna Hubers after the shooting, but before her interrogation, testified about some other bizarre statements that Shayna Hubers made, many of them very similar to the comments that Hubers later made in a jailhouse interrogation. Also on the stand earlier during the day, the medical examiner. He testified that victim Ryan Poston died of gunshot injuries. The bottom line here that might be helpful for the defense is that the victim, Ryan Poston, had 2 drugs in his system. One drug was in his urine, and the medical examiner said that that really shouldn't have affected his state of mind at the time he died. He may have taken that drug earlier, but that it wasn't currently in his bloodstream. But another drug, a mild sedative, was in his bloodstream. Questions now are going to perhaps revolve around whether that drug played a role in the way the victim was behaving. The medical examiner says that goes beyond his expertise. He's there to determine a cause of death. He determined that those drugs had nothing to do with the victim's death. So that's where his inquiry ends. So possibly a window of opportunity for the defense there when testimony picks up again. This is Aaron Keller reporting from Campbell County, Kentucky.
Great reporting from our very own Aaron Keller. Want to bring back in Kendall Coffey to talk a little bit more about this. Kendall, the text messages. We got to talk about these text messages. The ones that she sent to her friend before the shooting. When I go to the shooting range with Ryan tonight, I want to turn around, shoot, kill him, and play like it's an accident. That was about a week and a half before she actually killed him. Then she sends a text to her friend, who's a dentist, saying, I want you to mess his teeth up so he's so ugly another woman wouldn't want to be with him. Kendall, what's your reaction to these text messages?
Well, some of the worst texts you could possibly imagine in the context of a self-defense case. She wants to mess up his mouth. She wants to accidentally shoot him. Yikes. That is one tough couple of texts to survive. So what do? They say that this was her. You know, she just had a way of strange banter. But the strange banter defense is pretty difficult to survive with when, in fact, there's 6 shots to the face.
Yeah, couple that with also, you look at her interrogation tape where she's singing Amazing Grace. She's saying, I did it. Yes, I can't believe I did it. I did it. And saying, I wanted to give him the nose job that he always wanted. You couple all that together, not looking so good for the defense, but this is really the beginning part of the trial. And we're going to analyze a little bit more about the drugs that were in Ryan Poston's system, like Aaron said. When we come back from our break, though, we are going to start with the Shayna Hubers 911 phone call. Stay tuned. Wow. Let's bring back in Kendall Coffey, former federal prosecutor. Kendall, in your opinion, is that someone who is naturally hysterical after this event, or someone who has very calculated answers to questions she wasn't even asked, saying things like, this was self-defense, and throwing a lot of information out there before she was even asked? What do you think about that?
Well, it sounded like she had made the call with a made-up story. She got shaken. I mean, she didn't keep coldly and analytically to script, so she jumped around a little bit. But it does not sound like a spontaneous call to me. I have to say how impressed I was with the 911 operator because the individual was very calm, kind of kept asking good questions, really seemed to have great training and a great demeanor for what is obviously a very dramatic and intense call. I think the net effect of that 9/11 call, and it actually kind of really hit me when she talked about how he was twitching, and she had to finish him off. I mean, that's appalling, isn't it? Doesn't it sort of give you almost a physical reaction to picture that? So 911 tape is the defense will have explanations. They'll try to argue to a jury that when people are undergoing shock and something like this, everybody has different reactions. People can sound very, very scattered, confused, say things that may not even be true. But boy, that's going to be very tough evidence for the defense to overcome.
People might not believe everything that she said, but as you said, Kendall, the idea of him twitching, I'm concerned that that's actually what was happening, and that is an image that's not only in all of our minds, but also in the jury's mind as well. But let's couple that now with what Shayna Hubers told investigators when she was interrogated. I want our listeners and our viewers to watch very carefully, because this does not help her case. Take a look.
It was so painful to watch him die and to know that I had done that. That I just walked around the table and shot him where I knew he would die immediately and fast. His obsession with guns killed him. I would have never, I'm so Democrat, I would have never touched a gun in my life until I dated him. His big thing was, let's go to the range and go shooting. He was very Republican. His parents made fun of me last night because I was Democrat.
Okay, Kendall, I have a question about this. Is it a little strange that she goes from hysterics, saying, I was watching him die, it was so painful, almost then directly going to, it was his obsession with guns that killed him? It felt a little bit like a monologue from a high school play.
Yeah, and again, it suggests that this was planned, or even if it happened out of anger, that she had a story that she was trying to quickly create. What can the defense do? Again, what we talked about a little bit a while ago, say that, look, nobody knows how one would react when something so dramatic, so tragic, so horrifying takes place. People can even cry. They can laugh. They can be paralyzed completely and can't say a word. And so the defense has got to argue that you have to minimize kind of her conduct, her demeanor, and other things, and recognize that it could just be a function of grief of a woman who'd had this horrible moment in her life where
right,
she was...
and they keep saying she suffered from an extreme emotional disturbance. I wonder how much they can play that into that you want to say it? This is just a sign of that. When we come back, a lot more of the interview. That is Shayna Hubers. Welcome back, everybody. I'm here with Kendall Coffey to talk a little bit more about it. Okay, now, some people could look at that and say that's very bizarre. Other people might look at that and think, is she relieving stress? The question is, when people look at that tape of her doing this, they say it's a stream of consciousness. She's going through a million thoughts. When she says, I did it, do you sense the feeling of she's proud of this? That's what she did? She's relieved? And also, the defense is clear to say that this is a sign of an extreme emotional disturbance. Can they say, hey, look at this videotape. She's not all right. She's not okay. It feeds into our defense.
Yeah, well, I mean, of course the defense has to say that. They have to say it shows that she's disturbed, that she's having an emotional breakdown, even while recognizing that they're not going to be able to establish the elements of a defense of insanity. But I think that the words, I did it, and combining with other things, twitching, her text to a friend about how she was going to stage an accidental shooting with him on the shooting range. The comments she apparently made to a cellmate in a jail, or allegedly made sort of bragging about the crime. There are just too many pieces that match up. And the fact that she seems to be very confused and, capable of bizarre things is also consistent with a murder, because a lot of murders are people with a lot of strange impulses, a lot of strange reactions, a very complicated psychological picture. So ultimately, the defense has to try to make something out of that, but I think a juror's common sense is going to tell him, yeah, this is exactly the kind of person, given all the different comments she made, who would keep shooting 6 times and then make a reference to he wanted a nose job and shoot him in the face. So yes, it's a crime committed by somebody who was not well, and she is seeming to be confirming that she well fits the profile of the murderer in that crime scene.
But as you said, Kendall, it just might not be enough to get her off of this, but it does show signs of what this woman was going through in her mind and how this might have all unfolded. I want to play a little bit more of her police interview, and this is where she talks about Ryan Poston's family. Take a look. I could watch these tapes all day, but unfortunately we can't. We have to analyze a lot of it, too. I'm here back with Kendall Coffey to talk more about this. Is there a sense then, I wonder if you're sitting on the jury, are you confused by her? In one sense, she seems to say, I did it, I can't believe I did it, but she feels bad for the family. In one sense, she's wanted to kill Ryan in the weeks leading up to this, but at the same time, she seems to show a little humanity. What is the jury supposed to make of Shayna Hubers?
Well, they're seeing, like most people, they're seeing a range of emotions, and I think it's frankly entirely consistent with guilt that, especially if it was an impulse killing or something that, connected to in some way her hurt and her anger. It's not unusual for a killer to express some sympathy for the surviving family members. So it's going to give the jury things to talk about when they go back there. She's complicated, strangeness, bizarreness, how does that play into the fact that she's a killer? But I think the prosecution will make it clear that a lot of killers are not very normal people, and a lot of killers have a range of emotions and say a lot of different things.
And
but
Kendall, when we come back, because we have to take a break, I'm going to ask you the million-dollar question. Will she take the stand? So think about that. We'll be right back. Okay, let's talk a little bit more about this with former federal prosecutor Kendall Coffey. Now, does it really matter what was in his apartment? At the end of the day, yes, there was a gun. We know that it was used, and we know that she shot him. So what does it really matter what else was in the apartment?
Well, I think from her standpoint, she'd like to portray a guy who, loved guns, was dangerous, and ammunition everywhere, to add to some sense of peril. So if you're her lawyer, I think you'd want to talk about as many weapons as possible.
All right, I asked you a question before our last break, and I'm going to ask you again. Before our last break, we were playing a little bit of Shayna Hubers in the police interview, and then we're going to talk about her text messages later. Do you think she's going to take the stand in this case?
Well, if I were her lawyer, I would recommend it. It's maybe a real long shot. But she was convicted last time. The jury recommended 40 years. They've got to do something different. And I think the different faces, the different voices that we've seen so far of her are not sympathetic. They're confused, they're erratic, sometimes they're bizarre, but they're all consistent with somebody who could, in a rage, in an anger, in a jealousy fit, kill a boyfriend, ex-boyfriend. So the real question is there a way to craft a narrative that explains everything and acknowledges things like that and presents her as a human being that's not crazy, that's lethal, that's confused, and out of confusion and hurt and some emotional instability, shot him believing it was in self-defense. But I think she really needs to take the stand, and it will not be easy, But I think she needs to take the stand if she's going to have a shot at a not guilty.
Well, I'll tell you this much. From a selfish perspective here at Law and Crime, it would be great if she took the stand. It would be pretty fascinating to watch. But I want to play right now some more of the testimony of Lieutenant David Fornish, because now he's going to talk about the gun, the very gun that was used in this event. Take a look. Okay. This is pretty big right now, and I want to bring back on Kendall Coffey. The idea of there being no struggle, that goes directly against what Shayna Huber said.
Yeah, it devastates self-defense, and especially if there's a very specific correlation. She said she was thrown against the bookcase. Anyone and everyone would imagine that that means some books are knocked around, some things fall to the floor. The police witness is saying nothing whatsoever. The dust was still there. So that is a devastating bit of evidence in terms of her self-defense claim.
You can have witnesses who lie, but that evidence is really hard to fight against. But you know what? Let's see how this officer did under cross-examination by the defense about this very fact. Take a look. All right, Kendall. Is this a really good area of questioning? Yes, they're asking him why he didn't question her further, but she asked for an attorney. What are they trying to get at here?
Well, they're trying to get at the fact that this wasn't fair, that there was an attempt here to ask her a limited number of categories, not get the whole truth, nothing but the truth, but just try to get the goods on her and focus on things that were incriminating rather than a complete picture of what really happened.
So I find it fascinating what the defense is trying to do. What kind of witnesses do you think they're going to call in this case when they're eventually handed it?
Well, we don't know what the pretrial judge rulings are. In some trials, they will allow psychologists to testify about the impact of shock, the emotional disarray that people who are involved in a violent crime have in its immediate aftermath. You can't really get on a witness to be a lie detector and to talk about her being truthful, but sometimes judges will allow witnesses to explain the personality and why she would be acting in such an erratic way. I think they will try to also, if they can, address, for example, the text she sent to a friend talking about shooting him by accident. Did she, in fact, have a bizarre, maybe unsettling banter, but it was nonetheless not real? Is she capable of making statements that were not really serious or intended?
Well, it'll be something to watch what the defense does when they're handed the case, but we're still in the beginning parts of it, and there's a lot more to cover. Now, when we come back from our next break, we are going to talk about the new case out of Texas, the Roy Oliver case, an officer who has been charged with the murder of a young 15-year-old boy. We keep seeing these cases, and we really shouldn't. So we'll be hopefully live in that courtroom. Stay tuned. We'll be right back. And welcome back to Law and Crime, everybody. So we are live in a brand new case here on the network. It's out of Texas, and it's the Roy Oliver case, a police officer who's been charged with the murder of a 15-year-old boy. And the reason is he's claiming, hey, listen, he was in a car, it was driving back. I thought it was going to hit my partner, but I opened fire. But the evidence in the case may suggest something else, that there wasn't this threat, this present threat, and perhaps he used excessive force. I'm here with former federal prosecutor Kendall Coffey to talk a little bit more about this. We saw something earlier on in the case which was very interesting. This officer was obviously had a conversation, was being interviewed by Internal Affairs, and he was required under his job to speak to Internal Affairs about what happened. But now it became a question of whether those statements can be used against him by the prosecution in this case. And based upon what the judge just ruled, it appears that they can be. What do you think about that?
Well, it's the kind of thing that could be an issue for an appeal, because the defense argument was, look, this was an internal affairs investigation. He is supposed to get immunity because police departments want to be able to police their own. They want to be able to get truthful statements from people who are being examined or the subject of an inquiry. And so you want them to say what happened without fear of criminal prosecution. So there should have been, according to the defense lawyer, some form of immunity. Obviously, the judge felt that there were at least some parts of the internal affairs investigation that weren't immunized, and he was going to look at it later in the specific context of specific statements that the prosecution attempts to admit. But a defeat for the defense and possibly a future issue for appeal if there's a conviction.
Let's see if we have a live feed. You know, it's a really interesting scenario. So Kendall, we're not going to jump back there live yet. So I have another question for you, and I'm glad you're here because this is really an interesting new case that we're covering here on the network. The idea that he was trying to protect his partner, that the car was backing up, is that a valid argument here? Can that really work? I mean, you have, can we show, I wonder if we can show the picture of Jordan Edwards. I mean, this young boy who was killed. It doesn't compute for me, but how can it compute for a jury?
Well, this looks like an ultimate innocent victim, and the jury's going to be deeply disturbed about why his life was taken away from him and why this young man was taken away from his family. The police officer probably knows that department policy requires that if he sees an oncoming car, and again, there seems to be evidence that the car wasn't oncoming, you're supposed to get out of the way. Police departments throughout the country are now trying to get their officers to say, don't start firing away into a car. Get out of the way if you can, because if you start firing into the car, not only is it hard to know whether you have an avoidable situation, but you could very easily kill somebody who's innocent. So I think what he's trying to argue is that, well, even if he could have gotten out of the way, he had to protect his partner, and that justified the excessive use of force, because self-defense can be applied to defend someone else if there is serious imminent threat of serious bodily injury or imminent threat of death. So I think he's trying to justify why he simply didn't get out of the way.
Well, hopefully we'll learn a little bit more when the opening statements begin, but I want to jump live into the courtroom and we can hear more of the discussion between the judge and the attorney. So let's go live. Great reporting as always, Anthony. Go to lawandcrime.com to learn a little bit more of the top trending stories of the day. I want to bring back in Kendall Coffey, former federal prosecutor, to talk about the upcoming case that we're covering here right now, and that is the Roy Oliver case out of Texas. We are waiting for the opening statements, and I got to ask you about the opening statements in this case. When you are delivering an opening statement as a prosecutor, what do you need to do in this case, specifically when the defendant is a police officer?
Well, you've got to address that because police officers as defendant not only get the benefit of reasonable doubt, but a lot of times in excessive force cases, they get the benefit of doubts that aren't very reasonable. So you've got to remind the jury what they'll hear over and over again. Nobody's above the law. Police officers have to follow the very same laws that they enforce, and then just go through a very fact-specific chronological narrative of how an innocent 15-year-old was killed in a car that was actually moving away from the police officers, and multiple shots were fired. I think it's a compelling case for the prosecution. But as I said a moment ago, it's never a certain thing convicting police officers in excessive force cases, because juries see them, and the defense attorney will certainly emphasize they're on the line protecting all of us. They have to make split-second decisions, and we sitting comfortably in a courtroom can't know what was really involved and have to recognize that they make the decisions split-second in order to keep the rest of us safe.
You would presume, though, during the voir dire jury selection process, that they would ask these jurors about their predilections towards police officers, how they feel about police use of force, right? These are the questions they would try to get because you want an impartial jury.
Yeah, and these things have to be covered, and everyone who goes to a jury on an excessive force case already has heard a lot about excessive force cases. They have attitudes, things that they've seen in the news, and a lot of times these are the kind of cases that are won or lost in jury selection.
And then got to play devil's advocate here. So we talked about the prosecution, what they need. What does the defense need to do in their opening statement? And who do they ultimately hope is on that jury?
Well, they hope that there are people on the jury that have family members with police departments or family members with military, family members that somehow connect to the law enforcement or other sides of life that affect all of us. And I think they've got to paint a very dramatic, confused scene of the time this occurred, that the police officers thought they heard gunshots, that there was a commotion, that there was disruption, and that it wasn't like a calm, clear day where you have plenty of time to make a decision.
I mean, we are going to hear second by second and word for word about what happened on that day and try to understand, because right now I am left with more questions than I have answers, and hopefully during the opening statements we will get more of a roadmap about where both sides are going to go. So Kendall, stand by. We'll take a break on our end, and when we get back, we know the jury is being called in. We expect the opening statements. So come back after this break. You're not going to want to miss anything here on Law and Crime.